My name is Tom King. I'm the founder and CEO of Toolkit.law, catering to those 80 countries with English-based legal systems. And today we're joined by an attorney friend of mine, Quyen Pham, who has participated in our CLE events before with me. She is a family law and a child welfare law attorney here in the United States, like me. And we're going to cover a help sheet that we've put together, and it's called client and witness preparation when it comes to child welfare cases. Now, some of you, Quinn, some of us in America, we like to think of two different buckets, right? Family law and child welfare law, but they really do overlap, don't they?
Yes, they do a lot.
And so let's go ahead and look at our help sheet right here. I'm going to walk us to the left side. You jump in what you want to talk about, and then we'll do the yellow side, the right side for you. But obviously, it's important to establish rapport when you're dealing with law enforcement and child protective services types agencies that are investigating cases. I'm sure you've had cases, Quinn, where you wish the relationship with law enforcement was better or you benefited from it because it was.
Right. I think it's always a fine line of, you don't want to make them a hostile witness, but also you still want to be able to pull out, especially if there are some, there's some, as far as their investigation, if there's some errors in the way that things were done, but at the same time, you want to be able to point those out in their testimony, but also not to make it too much of, turn them too much of a hostile witness.
Of course, we want to always prepare our witnesses for cross-examination. Um, and of course, we want to review investigative reports and evidence. That's pretty basic. But talking to social workers and other experts, you can find out so much from social workers who have interviewed the parties, and they can be hostile or they can be helpful, can't they?
Yes, I guess depends on which side you're on, right?
So when we talk about discussing potential cross-examination topics, to me, you want to prepare law enforcement witnesses for the questions that they're obviously going to get, but you also want to make sure that they understand witness predicates, right? So if you're trying to get some witness a witness get a piece of evidence in, make sure you practice with them how to get that in. I also think about when it comes to handling child testimony, so important that if children are involved in a case or if children are being interviewed by a judge in chambers, different rules are going to apply because you don't want to coach a child to where the judge says, did the lawyer tell you what to say? And the worst thing they could say is yes, right? But you do
Right.
have to do some amount of questioning. I know, Quinn, for a fact, you've had many cases where children have not only been interviewed, but have also been interviewed by judges in chambers.
Right. I mean, I have, but as far as talking to children, because unless I'm the ad litem and I represent the child or the children, I actually don't, try talk to them. The only time I try to talk, that I do talk to them is when my client actually do, ask me to for whatever reason. But I do keep it brief because for the reason of I don't want it to be, if they do go end up talking to the judge, I don't want it to have that I've talked to them at links or anything like that. So actually, unless I represent the children, I don't talk to them. I avoid it.
So obviously we want to be aware of allegations regarding bias. And if there's going to be any claims that the investigation might be tainted, we obviously need to prepare them for that. And we need to protect sensitive information in court because if it's on the record, but it's a type of information that needs to be sealed, we need to think about that. And finally, when you need to be preparing for the impact of new evidence. So you need to think what type of what type of evidence makes the judge or the jury go, holy moly, where did that come from? You have to be prepared. You have to ask the questions of your investigative witnesses to find out whether or not there's something they haven't told you that we need to guard against. Let's now go to the right side of the column, your side of the column, Quinn. Talk to us about parental witnesses.
Um, and that's, I represent a lot of parents, but I do think, preparing them. on how to present. Obviously, it starts with, how they come to court, how they're dressed in court, as well as, their emotions, their body language, and how to remain calm. And also, one of the things that's really hard is, explaining to them how to answer the questions directly, just short and brief, even if they have the need to elaborate. Not to elaborate, especially if they are being examined by the other side. That to wait until, I ask an open-ended question for them to elaborate. But if a question just requires yes or no, then just answer yes or no. And that's something really, that's hard for most witnesses to grasp or understand.
Of course, a lot of times it's important to let your witness know what it is they're delivering, right? If they're the
Right.
sole, if they're the sole party that saw one certain aspect, talk to us about identifying key facts that you need to make sure they know they need to articulate it in their testimony.
Well, I mean, if they are my witness, I normally try to send over almost like a script, if you will, meaning, a list of questions so that they already know what, questions are going to be asked, and, we can go over them together. But also, also sometimes I have to prepare them for what they might be asked on the other side, but I can't fully prepare for them for that. But only all the things that could possibly come up. So I do try to, kind of have a script. So like that way they already know what kind of questions they're going to be asked. So they're not, there's no surprises. And then we go over how to answer the questions and stuff like that. Um, like I said, I try to guide them that, hey, you answer that question this way. But they start, they'll always start, if it's yes or no, they always want to say yes or but. So I kind of explain, point that out to them again, that they just answer more than necessary for the question that might be presented. Um,
And not only how you prepare them for being a witness, but talked about the role of parental involvement in child welfare cases, right? Because they're going to be they're going to be interviewed by some potentially hostile or not similarly aligned people asking them questions, right? Law enforcement, child protective services, um, school officials. What do we need to talk to them about when it comes to the role of parental involvement in child welfare cases?
well, it depends on like I said, it depends a lot on who the parents are. Are they the person that is being accused of neglect or abuse, or are they the other parent that's having to go through this process because the other parent has been accused? So there's a lot of it, but of course, it's important. It's important that I let my client know that they shouldn't lie. But obviously, if there are any questions that come up that there might be any criminal charges or anything like that that could come of it, that they need to be careful of, and there should be, their Fifth Amendment rights. But obviously, even just discussing if there's any situation that is already involved, as an attorney already involved in the case, then I don't even allow, I was to for them to talk to any law enforcement without me being present. So of course, me being present, then I can advise them, what to answer or what to, how to answer certain things, or say don't answer if a question comes up that could possibly criminally, implicate them in any kind of way.
And you mentioned the Fifth Amendment. That's obviously an American concept, but of course, in any of your jurisdictions, you may have areas that protect you from providing evidence against yourself. So that is our Fifth Amendment reference to the United States Constitution. Your constitution and laws will control. Now, obviously, you got to prepare them for the tough questions and help them think through that. Not to overly coach them, but to really help them understand what they could establish and how it could be beneficial or not beneficial for them, right?
Right.
Now, let's talk about managing cross-examination of parental witnesses, okay? On parental fitness. So when we're preparing parents for cross-examination about whether or not they are fit to be the one responsible for the child, what are the things you cover with them? How do you walk through that with them? What do you point out to them?
As to so that they are fit to be the the parents take care of their child, the primary parent or the primary conservator. I go over to the, depends on the facts of the case, but if they've been the one to take care of the child or the children, I try to, point out those things, that who's been the one to take, to care of the children, such as taking to doctor's appointments, schools, helping them homework. Um, so things like that also.
School
Um,
appointments, right? Teacher conferences,
right.
extra, extra, extracurricular activities, assistance.
Right. All of those, like how involved are they? Kind of walk through pretty much an average day or an average week with them, with their children. What do they normally do? And what kind of activities they like to do,
Oh, I
as well as
like that. I like that. Tell us what an average day or an average week is. What a great, kind of open-ended question, right? Well, it is.
right.
Ooh, I
Right.
like
And
that.
yeah, so of course, if they're if they're super involved, then they'll have a lot to talk about. As far as what they do to children, and also it kind of gives them a chance to also disclose or show how much they do know about their children, through the activities that they do together.
Sometimes it's important that we help our witnesses discuss the support system that they have in place. If it's a single parent and they work a full-time job, what do you help them understand they need to share about? Is it a village that's helping, or is it just one parent, right?
Right. I mean, obviously, if they have, a support system, then of course we elaborate on that as well, but also not to the extent that we still don't want to show that other people are the primary caretakers of the children. But we do want to highlight that they do have help, that if an emergency comes up, who can they call on and stuff like that. But definitely we don't want to make it, if it's a situation where, they rely a lot on their support system, that we don't want to make it sound like they can't do without their support system. So there is a fine line with, having help, but also relying on the help too much, to where, the children are spending more time with the village versus the parent.
And of course, it's going to be different per culture. I reflect a month ago when I was in Pakistan working with the Toolkit.law team, and I stayed at the home of my partner. And it was it was his parents, then it was his brothers and his unmarried sisters and his married brothers. There are 15 people in the house. They have a whole village in one house to help support. And they were all helping. And so obviously that's going to change culture to culture, how you're able to point out the infrastructure that you have in place, the network. Um, let's talk about these last two boxes on this column: reassuring parents about their role, and then preparing parents for an emotional cross examination.
Right. I mean, um, which is that it kind of touches up what I already taught, kind of touch up with last topic, is that we want to make sure that we really point out and really focus on how involved they are, as to the children, as a parent. And as far as emotional, obviously, you know depends on the facts case, whether there's been abuse or neglect allegations. They It does get emotional to talk about those issues. So they is emotions will come out, and they will have to, while remaining calm, but also show that they care as well. And if there's anything that they could do to, either if they're the parent that has, committed the abuse or neglect, what they can do to resolve or avoid that issues, those in the future, and what steps they have taken to avoid that and not do those, make sure that those things doesn't happen again. That the reason why we are in court to begin with.
So let's go to the second side of our child welfare client witness preparation. Let's talk about hostile witnesses, right? Hostile witnesses, as legal professionals, those can be those can be fun, right? It's for us, it's a sport, right? Because it's
Right.
it's the challenge, but there's a solemn responsibility to be respectful, to be truthful, and to not try to get them to say something that they don't understand, right? Because judges and juries will see through that if you don't play fair with the hostile witness. That's sort of my first thought coming from my criminal prosecutor background. But when I think of angry witnesses, there's going to be a whole range of frustration, of emotions that they may share as a hostile witness, and not all of it's going to be bad, right? They may
Right.
be righteously upset at a position that they believe you're taking when questioning them. So whether they're angry or non-cooperative, you need to be clear, you need to be crisp, and never ask a question to which what?
That you don't know the answer
To
to.
which you do not know the answer on cross-examination. That's absolutely right. you know
Um,
and I always like, yes or no, did this happen? Yes or no, yes or no, to where they only have one answer to go or the other. And if they start to not follow your instructions, the jury and the judges can see they're being hostile, and the judges may jump in to keep them on track, and that's certainly beneficial. What were your thoughts, Quinn?
right. Well, I mean, just saying that for me, it's important that I don't come across, because I do think it kind of, perspective, right? Um, so I wouldn't want the jury or the judge to have a bad perspective of me in my case because of how I'm coming
Oh,
across.
yeah.
So I always want to make sure that I come across, friendly and professional. So where it gets hostile is, hopeful, you know, is that they got hostile. And at that point, I'm just, I'm maintaining, but but I don't want it ever to come across that I did something or try to get them to be hostile on purpose.
Absolutely. So, now there will be times when witnesses are evasive to where they're not trying to answer the questions directly. And that's when you need to stay laser focused, and you need to take them down that yes or no, this, yes or no, that, take them down that path, and then have the evidence that's admissible to show if they're either lying, or say, well, now that you've seen this, does this change your opinion? For instance, did you know he's an alcoholic? No. Well, you're here testifying on his behalf. Now that I've shown you evidence that he has a DWI, is this still the type of person you would want driving your kids to T-ball, to football, to soccer, to cricket, to whatever activities there are? So I always like to say, now that you're aware that he's a complete liar or a drug addict or an abuser, is he still the great person in your eyes that you would trust your kids with? Um, so you have hostile witnesses, you have evasive witnesses, and amen if you get an unprepared witness, right? And
Right,
that's a great day. That's a great day when you have an unprepared witness, unless it's your unprepared witness. Do you have any
right.
thoughts on, well, we were just talking on the past screen about the importance of preparing witnesses. You need to ensure that they understand that their testimony, they need to understand it fully. They also need to understand that what they're doing is important, so they stay focused. Okay. And Lord knows, I'm sure, like me, you've had those clients that no matter how hard you try, they just can't stay focused when giving answers, Quinn.
No, I mean, and I think when they don't answer your question, it's pretty obvious that they're avoiding it. So I think even that in itself is a question, right? It's kind of like inaction is also an answer, right? Like no answer is an answer. So essentially, sometimes when they avoid answering your questions, that is essentially the answer. It tells a lot to the judge and the jury. So,
Right. Your
um,
your honor, may the record reflect that he refused to answer the question.
right.
Again,
And I think,
again,
right,
again.
right.
Got to get that last one in there. Let's talk about social workers. Depending on what you call them in your country, there will be government people who are with agencies that ostensibly are there for the best interest of the children. In some parts of the world, these areas don't necessarily have good reputations, do they?
No,
Yeah, in America, Child Protective Services, many times you're going to find many attorneys have very jaded opinion of these people who always take sort of one approach. Like if their approach is always mom good, dad bad, right?
Right. Or just, I mean, or they just don't, they treat every case the same, that they don't, and then all, and I know a lot of attorneys feel like, they don't do their investigation. They're not detailed enough. So yeah, there's a lot of that I feel that, the CPS has a bad reputation for.
So obviously there will be times when you have professional witnesses like a therapist or an expert witness. Of course, if it's an expert witness in many countries, they have to turn in their reports in advance. And you really want to find ways to where their testimony is different than what they wrote up in the report and say, well, I can see you've changed your mind. So was it six then, or is it now 4 beers a day he's drinking, right? Or
Right.
whatever the discrepancy is. We've got about 8 minutes left. We're going to switch to the last column, which is your column. So let's talk about impeachment evidence, because one thing you can do is get witnesses to admit, you know what, I was lying, but that doesn't happen a lot, does it?
No,
It should. They
no,
should.
they're not gonna admit that.
They, they, they,
Not unless you have something to, show them, like you said, impeachment, to show them that they're lying, that they might, even then they probably won't admit that they lied.
or okay, well, let's watch the video.
Right.
Oh, you did have 12 beers that night. Okay. Good job, mom. Okay, let's identify. So let's talk about impeachment evidence. Obviously, if they're on the stand saying X, and previously you can prove that they said something other than X, that's impactful.
Right. No, I
And
mean, it's very, because I mean, obviously, once you can impeach them and discredit them, just even one or two questions, pretty much all of their testimony now is being questioned, because now we don't know, if they're telling the truth at all now, or, were they telling the truth then? So it's definitely helpful when you're able to do that, because it does discredit their whole testimony as a whole.
And of course, obviously, documentary evidence. I think of either child support payments when they say, "Oh, sure, I'm up to date on my payments," and you say, "May I please present to you your child support payment history that shows you're $1 million behind?" Or, "Yes, I was at the teachers' conference, and you have the school records that indicate that only one parent was there, not both." Right?
Right.
Let's talk about impeaching expert testimony. Any additional thoughts? I know we kind of covered that.
I mean, I think it depends on obviously whose expert it is, but depends certain expert. You might want to have your own expert to challenge, an expert in position, if you will. So unless an expert witness really has some, um, there's really some holes in their reports, or they really did anything wrong. But if you just disagree with the position, sometimes it's just best to probably have your own expert witness to present a different position than what the other party's expert witness. So it just depends on what is in the report that you're trying to discredit. Because if you're just disagreeing with their position, then I think it's best to have, maybe possibly have your own expert witness as well.
And of course, let's talk about criminal records and criminal behavior. So the one thing that comes to mind is it doesn't necessarily have to be criminal convictions if they were investigated for something that relates to whatever the burden of proof is, right? So in many jurisdictions in America, the standard is the best interest of the child. Well, if one parent was had something to do with child pornography and they were investigated 3 different times, but the prosecution chose not to move forward for some reason, sometimes that is still admissible, isn't it, Quinn?
Yeah, I mean, yes, depends on, like you said, what's going on with those charges and stuff like that. Um, or was it dismissed, whatever the reason. You can try to get in, obviously, through other factors, I mean, other, facts and stuff like that. But I do know that depends on, because I do know that, um, there's a reason why that we do have our system is innocent until proven guilty, right? So I do think that there is a fine line of introducing and actually getting in. Depends on what you're trying to get in with that, because unless you're trying to get in a conviction, that's difficult. But if it's just, I guess, was it 3 charges and all of them were dismissed, then I can see how you might try to establish a pattern of behavior with that. I'm
Right.
not sure if that's where you're going with it.
Right. So isn't it true that you had 6 beers on that at that picnic? Yes. And that you were stopped and questioned about public intoxication? Yes. And you were about to get into a vehicle? Yes. They advised you not to. And did you drive? No, because he told me not to, because he told me I was drunk. Well, you didn't get convicted of anything. Might have gotten a warning. Judge is certainly going to want to know about that, depending on the rules of the jurisdiction, right?
Right. And I think that if it's just a warning, right, I think that's hard to prove that. So I think what if the witness lies about that? How are you going to prove that that did happen? Because
Well,
that's the big problem with the
video.
warning.
You also have family videos and you posted it on Facebook. There goes my dad stumbling through the park, right?
Right. I
Okay,
mean,
let's
yeah, obviously there's other evidence, right, to show that that incident did happen, then yes, that helps.
last 3 areas. We got about 3 minutes left. Challenging motive or bias. Obviously, if somebody has a vested interest in an outcome, what do you want to do when it comes to questioning?
I'm not sure I understand what.
So obviously, if somebody like if the mom is testifying and if she convinces the judge of what she's claiming, it may flip custody, right? So or which would mean she'd no longer have to pay child support if she were previously paying it. So if someone is motivated for a certain outcome, or if somebody has a bias, like mom's best friend is testifying on her behalf, we
Right.
obviously want to expose that.
Right. I mean, I think it's as far as the parties themselves, they're always going to be biased, right? Because each party is going to want uh, whatever's best for them. But as far as witnesses for bias, yes, I do try to, even with those biased witness, I do try to limit them as well with my clients. Because I know a lot of times clients will want to bring in, 5 family members. Well, I have to remind them, are they all going to say the same thing? And keep in mind that the judge knows as well the jury knows that, hey, they're biased witnesses, they're your people, they're going to say whatever you want them to say. So, there's no need to put in 5 testimony of the same thing. So a lot of times, even just biased witness, I try to, I do ask the question of, well, what are they going to testify to? Is it something that they've witnessed? Have they witnessed your parenting skills, right? Versus just coming in just to testify that you're a great person.
Let's look at the last 2 boxes for the last minute. How important is it to present prior testimonies to expose discrepancies?
Oh, I mean, that's very important if you want, because you want to show that, show the judge that you can't, the judge can't rely on their testimony today because they've said something else in the past. So that is very important to do if you have evidence of that.
And then the last box, when there's physical evidence, if it's not favorable to your client and you believe it needs to be attacked, you need to know the predicates to be able to attack it, correct?
Right. I mean, you have to be able to, in that case, like if you're talking about medical records, then you might also need, the medical professional who prepared the report to be able to question um, regarding the medical records.
Okay. Well, that concludes our presentation today on child welfare, client witness preparation. Thank you. And this concludes this recording.